Indian Polity, First Chapter, Historical Underpinning and Evolution of the Indian Constitution. Introduction. The East India Company, which came to India in 1600, managed to capture a substantial administrative power by 1765, aftermath of Battle of Buxar, when the British government caught revenue and civil rights justice. For Bengal, Bihar and Odisha, the trading company since then consolidated its power in such a way so as to reach every corner of our country. The success of the British in India was primarily to the administrative system they put in place through various statutes, which also led to the profound impact of the present form of the Indian Constitution. Many regulations and legislations passed before the Indians' independence can be traced back to the Constitution. The Indian Constitution evolution can be divided into two categories. First, the Company Rule 1773 to 1858, a set of rules that governs how businesses are run. Second, the Crown Rule 1858 to 1947, a period of British rule that lasted from 1858 until 1947. Regulating Act 1773, government headed by the Governor-General of Bengal and 4 councillors having the supervisory authority over the presidencies of Bombay and Madras. The Act recognized the right of Parliament to regulate the civil, military and the revenue affairs of the company's territories in India. Features of the Act. First step taken by the British government to control and regulate the affairs of East India Company in India. It recognized for the first time the political and administrative functions of the company, laid the foundation of the central administration in India, designated the Governor of Bengal as the Governor-General of the Bengal, and created an executive council of 4 members to assist him. First such Governor-General was Lord Warren Hastings. Inheritance of Indian national movement. These principles were forged during the long freedom struggle. The Constituent Assembly was giving concrete shape and form to the principles it had inherited from the nationalist movement. Perhaps the best summary of principles that the nationalist movement brought to the Constituent Assembly is the objective resolution moved by Jawaharlal Nehru in 1946. This resolution encapsulated the aspirations and values behind the Constitution. The Company Rule 1773 to 1858. During the Company Rule 1773 to 1858, various acts were passed by the British Parliament to control and supervise the activities of East India Company. The Company Rule ended in 1858, aftermath of the Sepoy Mutiny. Since then, the British Parliament took over the responsibility of administering India. Establishment of a Supreme Court at Calcutta, 1774, comprising 1 Chief Justice and 3 other judges, prohibited the servants of the company from engaging in any private trade or accepting presents or bribes from the natives. Strengthened the control of the British government over the company by requiring the Court of Directors, governing body of the company, to report on its revenue, civil and military affairs in India. Made the governors of Bombay and Madras presidencies subordinate to the Governor-General of Bengal. Unlike earlier, when the 3 presidencies were independent of one another. Pitt's India Act 1784 extended the control of the British government over the company's affairs and its administration in India. The Act distinguished between the commercial and the political functions of the company. Established a board of control to guide and control the work of the Court of Directors and the Governor of India. And the Government of India empowered the Board of Control to supervise and direct all operations of the British possessions in India, such as the civil, the military and the revenues. Charter Act of 1793 extended the overriding power given to Lord Cornwallis over his council to all the future Governor-Generals and Governors of Presidencies. Gave the Governor-General more powers and control over the governors of subordinate presidencies of Bombay and Madras. Extended the trade monopoly of the company in India for another period of 20 years. Provisions were made so that the Commander-in-Chief was not to be a member of Governor-General's Council unless he was so appointed. The Act also laid down the members of boards of council. The Act also laid down the members of the Board of Control and their staff. The Act also laid down that the members of Board of Control and their staff were henceforth to be paid out of the Indian revenues. Charter Act of 1813. In Europe, the spirit of laissez-faire and the continental system of Napoleon Bonaparte's had prohibited the imports of British goods into French allies in Europe. As a result, the British traders and merchants suffered heavily. The Charter Act of 1813 sought to redress the grievances of British traders and merchants. ended the trade monopoly of the East India Company in India, except the company's monopoly trade with China and ended the trade monopoly of East India. Charter Act of 1813. In Europe, the spirit of laissez-faire. Charter Act of 1813. In Europe, the spirit of laissez-faire and the continental system of Napoleon Bonaparte had prohibited the import of British goods into French allies in Europe. As a result of it, the British traders and merchants suffered heavily. The Charter Act of 1813 sought to readdress the grievances of the British traders and merchants, ended the trade monopoly of East India Company in India, except the company's monopoly trade with China and trade in tea. It asserted the sovereignty of the British Crown over the company's territories in India. The company's rule was extended to another 20 years. Powers of the Board of Control were further extended. Act granted permission to persons who wished to go to India for promoting moral and religious improvements, Christian missionaries. The Act regulated the company's territorial revenues and commercial profits. It was asked to keep its territorial and commercial accounts separate. Provision that the company should invest rupees 1 lakh every year on the education of Indians. Empower the local governments in India to impose taxes on persons and to punish those who did not pay them. Previous year question, prelims. Consider the following statements about the Charter Act of 1813. First, it ended the trade monopoly of the East India Company in India except for trade in tea and trade with China. Second, it asserted the sovereignty of the British Crown rule over the Indian territories held by the company. Third, the revenues of India were now controlled by the British Parliament. Which of the statements given above are correct? The right answer is statement 1 and 2 only are the correct statements. Charter Act of 1833. This paved the way to reconstitute an administration. Charter Act of 1833 paved the way to reconstitute. Charter Act of 1833 paved the way to reconstitute the administration on a new model to give it. Charter Act of 1833 paved the way to reconstitute the administration on a new model to give it an all-India character. Thus, the Act was the final step towards the centralization in British India. It attempted to introduce a system of open competition for the selection of civil servants. Company's monopoly over trade with China in tea ended. Legalized the British colonization of India, the East India Company, from the commercial body to an administrative body. Company's territories in India were held by the governments in trust for His Majesty in heirs and successors. Governor General of Bengal as the Governor General of India and vested in him all the civil and military powers. Lord William Bentinck was the first Governor General of India. The Governor General of India had legislative powers over the entire British India. Thus, the governors of Bombay and Madras lost their legislative powers. Laws made under the previous acts were called regulations, while the laws made under this act were called acts. The Governor General in Council had the authority to amend, repeal, or alter any law in British Indian territories. Governor General's government was called the Government of India, and the Council was called Indian Council. Indian Law Commission 1834 was established to codify all Indian laws. The first Law Commission had Law Macaulay as its chairman. Note: First Law Commission of Independent India. Chairman M.C. Settlewad. Neither a constitutional body nor a statutory body was established in 1955 for 3-year term. Since then, One more commissions have been established. The last chairman of the Law Commission was retired Supreme Court Judge Justice B.S. Chauhan. The Act also directed the Governor General in Council to adopt measures to migrate the state of slavery persisting in India since the Sultanate era, laid down the regulation of the establishment of Christian establishments in India, and the number of bishops was made 3. Charter Act of 1853, the last of the series of the Charter Acts passed by the British Parliament between 1793 and 1853. The Act empowered the British East India Company to retain the territories and revenues in India in trust of the Crown, not for any specified period. Unlike the previous Charter Acts of 1793, 1813 and 1833, which renewed the Charter for 20 years, separated the legislative and executive functions of the Governor General's Council for the first time. It provided for the addition of 6 new members called the Legislative Councillors to the Council, in 12 in total. Government of India Act of 1858, known as the Act of Good Government in India. It abolished the East India Company. It abolished the East India Company rule and transformed powers to the Crown. Rule of the Company ended, and Viceroy was the new designation of the Governor General of India, who was the direct representative of the British Crown in India. Abolished the Board of Control and Court of Directors, thus ending the double government. The office of Secretary of State of India was made. He was a member of British Cabinet responsible for British government. The Secretary of State was to be assisted by a council of 15 members. It was an advisory body, with the Secretary of State being chairman of the council. It focused on improving administrative machinery. Governor General of India replaced by Viceroy under the Crown, etc. of India. Indian Councils Act 1861 provided for Viceroy to nominate some nominated Indians in the extended Legislative Council. By 1862, Viceroy Canning nominated 3 Indians in the Legislative Council. This legislative wing of the council functioned as the mini parliament, adopting the same procedures as the British Parliament. Fourth member became a full member with a right to vote. Introduced an open competition system of selection and recruitment of civil servants. Thus, it was thrown open to all Indians too. Led to the appointment of Macaulay Committee on the Indian Civil Service in 1854. Number of board of directors was reduced from 24 to 18, out of which 6 people were to be nominated by British Crown. Act also introduced local representation in the Indian Central Legislative Council for the first time. Crown Rule 1858 to 1947. The Sepoy Mutiny, that is revolt of 1857, prompted the British Parliament to end activities of the East India Company. Henceforth, the powers of the Indian government, territories and revenues were transferred to the British Crown. Henceforth, powers of the Indian government, territories and revenues were transferred to the British Crown. The acts passed during this time are as follows. Legislative powers of Bombay and Madras presidencies were restored. It made provisions of formation of the new Legislative Council, Upper House for Bengal, formed in 1862, North-Western Province 1886, and Punjab 1897. Presidencies of Bombay, Madras and Bengal had more power than this. Viceroy was empowered to issue an ordinance without the consent of the Legislative Council in case of emergency. This ordinance was valid till 6 months from the date of the issue. It recognized the portfolio system, which was started by Lord Canning in 1859. Portfolio system. In it, the member of the Viceroy Council was made in charge of one or more departments and could independently take decisions and issue orders on behalf of the Council. Indian Councils Act 1892. Additional non-official members increased. In central and provincial legislative councils, official majority was maintained. Increase in functions of legislative councils. power of discussing the budget and addressing the questions to the executive. Provided for the nomination of some non-official members of Central Legislative Council by the Viceroy on the recommendation of the Provincial Legislative Council and Bengal Chamber of the Commerce. Provincial Legislative Council by the Governor on the advice of the District Board, municipalities, universities, trade associations, zamindars and chambers. Word election was nowhere mentioned, but limited and indirect election for the nominated members was introduced in this Act. Indian Councils Act 1909. Morley-Minto reforms. The Legislative Council was enlarged, and the Central Legislative Council members members were increased from 16 to 60. In provincial councils, the number were not uniform. The Central Legislative Council continued to have official majority, whereas non-official majority was allowed in the Provincial Legislative Council. More powers were given to the legislative councils. Members were allowed to ask supplementary questions. Voting for separate items on the budget were allowed. Budget as a whole could still not be voted upon. Separate electorate for Muslims introduced. Only Muslims could vote for the Muslim candidates. Lord Minto became the father of the communal electorate. Indians were allowed in Executive Council of the Viceroy for the first time. Satyendra Prasad Sinha was appointed as a law member of the Viceroy Executive Council. Separate representation for presidency, corporations, Chamber of Commerce, universities, etc. It was the first attempt to introduce the representative and popular elements in the council. Councils were referred to as legislative councils for the first time. The Government of India Act of 1919. Claims for reforms. Montfort reforms. Central and provisional subjects were separated with the power to make laws on their respective subjects. Element of dry chi was introduced. Dual rule, double government, division of the subject allocated to the states into two categories, one managed by executive branch, second by popular ministers who were Indians in the provinces. Provincial subjects were divided into two parts, reserved and transferred. Reserved subjects. They were to be administered by the Governor General and his Executive Council. They were not responsible for the Legislative Council. Transferred subjects. They were to be administered by the Governor General with the help of the councils. Transferred subjects. They were to be administered by the Governor General with the help of his council. They were responsible to the Legislative Council for these subjects. For the first time, the Indian Legislative Council was replaced by the upper and lower house of the Parliament. Bicameralism. Majority members were to be chosen by the direct elections. 3 of the 6 members of the Viceroy Executive Council were Indians, excluding Commander-in-Chief. Separate electorate for 6 Indian Christians, Anglo-Europeans, Europeans, element of communal representation. Franchise given to a limited number of people on the basis of property tax, education. Franchise given to a limited number of people on the basis of property, tax, education. Provincial budget was separated from the central budget, and provinces were allowed to enact their own budget. Provided for the setting up of commission to see the working after 10 years of these provisions provided for setting up of a commission to see the working after 10 years of these provisions coming into force. The Simon Commission was appointed in 1927 for this purpose. It was the first time the British government declared its intention of introducing a responsible government in the country. Previous year questions, prelims. Consider the following statements. First, the Montagu-Chelmsford reforms of 1919 recommended granting vote. First one, the Montagu-Chelmsford reforms of 1919 recommended granting voting rights to all women above the age of 21. Second, the Government of India Act of 1935 gave women reserved seat in the legislatures. Which of the statements given above are correct? The option is only two. Two only. That means the second statement only is the right and the first statement is wrong. Question number 2. In the context of Indian history, the principle of the diarchy refers to: first, divisions of central legislature into two houses; second, introductions of double government, that is central and statement governments; C, having two seats of rulers, one in London, another in Delhi; D, division of subjects delegated to the provinces of D, division of the subjects delegated to the provinces into two categories. The right answer is the D. That means, in the context of Indian history, the principle of diarchy refers to division of subjects delegated to the provinces into two categories. The Montagu-Chelmsford proposals were related to social reforms, educational reforms, reforms in police administration, constitutional reforms. The correct answer is constitutional reforms. That means the Montagu-Chelmsford proposals were related to constitutional reforms. Question number 4. The Government of India Act of 1919 clearly defined: first, the separation of power between the judiciary and the legislature; second, the jurisdiction of the central and the provisional government and the provincial government; third, the powers of the Secretary of State for India and the Viceroy; and fourth, none of these. The right answer is the B, jurisdiction of the central and provincial government. That means the Government of India Act of 1919 clearly defined the jurisdiction of the central and provincial governments. Question number 5. Which of the following is the principal features of the Government of India Act? Which of the following is the principal features of the Government of India Act 1919? This question was asked in 2012. First, introduction of the diarchy in the introduction of the diarchy in the executive government of the provinces. Second, introduction of the separate communal electorate for Muslims. Third, devolution of legislative authority by the center to the provinces. Select the correct answer using the codes given below. Option C, which says that statement 1 and 3 are the only two statements which are correct. Statement 1 is introduction of the diarchy in the executive government of the provinces, and the third statement is devolution of legislative authority by the center to the provinces. Salmon Commission 1927, mandated by Government of India Act 1919 to report on condition of India under the Government of India Act 1919. 7 members statutory commission, no Indian. Recommended abolition of diarchy, estimation of federation, continuation of communal electorate, responsible government. Recommendations of the committee were incorporated in the Indian Government Act of 1935. This is a previous year question which came in 2013. The question goes like: the people of India agitated against the arrival of the Salmon Commission because option A, Indians never wanted the review of the working of Act of 1919. B, Salmon Commission recommended the abolition of diarchy in the provinces. C, there was no Indian member in the Salmon Commission. D, the Salmon Commission suggested the partition of the country. The right answer is C. That is, there was no Indian member in the Salmon Commission. So the question goes like: the people of India agitated against the arrival of the Salmon Commission because there was no Indian member in the Salmon Commission. Government of India Act of 1935. All India Federation consisting of provinces and princely states. It provided for the division of subjects based on the central, provincial, and concurrent list. Residuary powers were with Governor of General. Princely states did not join the federation. Diarchy was abolished and provincial autonomy was introduced. Diarchy provisions in the center was introduced. Federal subjects were divided into reserved and transformed. This provision never came into being. Provisions were allowed to act as independent units of administration. Provinces were allowed to act as independent units of administration. Governor was required to act under the advice of the ministers responsible to the provincial legislature. This provision came into force in 1937 and repealed in 1939. Bicameralism, upper house and lower house. It came into being in 6 out of 11 provinces: Bengal, Bombay, Madras, United Province, Bihar, and Assam. Separate electorate. It was introduced for the depressed classes and women. Provision of separate electorate extended. The Secretary of State was provided with a team of advisors. The Council of India was abolished. Extended franchise. 10% of the people got voting rights. Reserve Bank of India to be established for the controlling currency and credit. Establishment of Federal Court. It was established in 1937. Significance. It was another important step. Introduction of the responsible government. Previous year questions. So this question came in 2018. The question goes like, in the federation established by the Government of India Act of 1935, residuary powers were given to A. Federal Legislature, B. Governor General, C. Provincial Legislature, D. Provincial Governors. The correct answer is B. Governor General. Hence, in the federation established by the Government of India Act of 1935, residuary powers were given to the Governor General. Second question. This question came in 2012. The distribution of the powers between the center and the states in the Indian Constitution is based on the scheme provided in the A. Parliamentary Reforms 1909, B. Montagu-Chelmsford Act 1919, C. Government of India Act 1935, D. Indian Independence Act 1947. The correct answer is the C. Government of India Act 1935. Hence the question goes like, question and answer both would go like, the distribution of powers between the center and the states in the Indian Constitution is based on the scheme provided in the Government of India Act 1935. Government of India Act of 1947. Government of India Act 1947. It was brought in the response to the Mountbatten Plan. It gave the provisions of partition of India with the creation of two independent dominions, India and Pakistan. These dominions had the right to secede from British Commonwealth. The Governor Generals were to be appointed in both Dominion of India and Pakistan by the King of Britain. Governor Generals were to be appointed in both Dominion of India and Pakistan by the King of Britain. The office of the Viceroy came to an end. Hereby the British King would not have any responsibility with respect to the Government of India. Gave the authority to the Dominions to govern as per provisions of the Government of India Act of 1935, or make modifications if need be. Constituent assemblies of dominions were empowered to frame and enact the constitution. They could also repeal any act, including the Independence of India Act. The Constituent Assembly could legislate over their territories till the drafting The Constituent Assembly could legislate over their territories. The Constituent Assembly could legislate over their territories till the drafting and enactment of the new constitution. designated the Governor-General of India and the provincial governors as the constitutional nominal heads of the states. Designated the Governor-General of India and the provincial governors as constitutional nominal heads of the states. Designated the Governor-General of India and the provincial governors as constitutional, that is, nominal heads of the states. They were made to act on the advice of the they were made to act on the advice of the respective council of ministers in all matters. It dropped the title of the Emperor of India from the royal titles of the King of England. The right to veto bills or ask for reservation of bills of the governor were reserved but were taken away from the British monarch. The office of Secretary of State was abolished and functions were transferred to the Secretary of States for the Commonwealth. The British paramountcy over princely states came to an end. They were allowed to be independent or join any dominion. Discounted the appointment to civil services and reservation of posts by the Secretary of the State discounted the appointment to civil services and reservation of posts by the Secretary of State for India. Significance: British rule came to an end by this act. India became 1930. Significance: British rule came to an end by this act. India became independent on 15th August 1947. First Indian Governor General of India, C. Raja Gopalachari. Do you know? The Indian Independence Bill was introduced in British Parliament on July 4, 1947, received the royal assent on July 18, 1947. The act came into force on August 15, 1947. The Indian Independence Bill was introduced in British Parliament on July 4, 1947 and received royal assent on July 18, 1947. The act came into force on August 15, 1947. The system of budget was introduced in British India in 1860. First Cabinet of Independent India. 1947. Members: Jawaharlal Nehru, Prime Minister, External Affairs and Commonwealth Relations, Scientific Research. Here is the portfolio. Sardar Vallabhbhai Patel, Home, Information and Broadcasting States. Rajendra Prasad, Food and Agriculture. Maulana Abdul Kalam Azad, Education. Dr. John Mathai, Railways and Transport. R.K. Shamgulam Chetty, Finance. Dr. B.R. Ambedkar, Law. Jagjeevan Ram, Labour. Sardar Baldev Singh, Defence. Rajkumari Amrit Kaur, Health. C.H. Bhabha, Commerce. Rafi Ahmed Kidwai, Communication. Dr. Shama Prasad Mukherjee, Industries and Supplies. V.N. Gadgil, Works, Mines and Power. Chapter 2. Making of the Indian Constitution. What is Indian Constitution? What is Constitution? A constitution is a body of fundamental principles according to which a state is constituted or governed. The Constitution is the fundamental law of land which fulfills the aspirations and goals of a society. It is an overreaching framework within which one pursues individual. It is an overarching framework within which one pursues individual aspirations, goals and freedoms. It defines the fundamental values that we may not trespass. It defines the fundamental values that we may not trespass. Constitution is living document which grows and evolves according to the needs and aspirations of charging society through instruments such as amendments to the Constitution, judicial interpretation and judgments, conventions and statutes. Significance of the Constitution. It gives us political framework and distributes decision-making powers. The Constitution exhibits our conflicts, aspirations, ideals of national struggle. The Constitution also gives one moral identity. It creates, reflects, and accords an Indian identity to individuals. Do you know Constitution envisions to establish an egalitarian social order, rendering Do you know Constitution envisions to establish an egalitarian social order, rendering to every citizen social, economic and political justice in a social and economic democracy of the Bharat Republic. Supreme Court observed in 1997. Do you know Constitution envisions to establish an egalitarian society? Do you know Constitution envisions to establish an egalitarian social order, rendering to every citizen social, economic and political justice in a social and economical. Do you know Constitution envisions to establish an egalitarian social order, rendering to every citizen social, economic and political justice in a social and economic democracy of the. Do you know Constitution envisions to establish an egalitarian social order, rendering to every citizen social, economic and political justice in a social and economic democracy of Bharat Republic. Supreme Court observed in 1997. Objectives of Constitution: to enable the government to fulfill the aspirations of society and create conditions for just society. To specify who has the power to make the decisions in a society. It decides how the government will be constituted. The Constitution is to provide a set of basic rules that allow for minimal coordination amongst the members of a society. To set some limits on what a government can impose on its citizens. Constitutionalism. Political philosophy based on the idea that government authority is derived from the people and should be limited by a constitution. Origin: Magna Carta 1215 of King John of England, an English Bill of Rights. The Western idea of constitutionalism is negative in orientation as it seeks to restrict dismiss power and limit the state. Components: rule of law developed by British ruler Dicey. Separation of power. India follows mixed separation of power model. Free press and media. Independent judiciary. Elected government. Temporariness of government. Demand for constituent assembly. CA 1924. Idea first given by Swaraj Party 1934. M.N. Roy put forward the demand of constituent assembly. 1935. INC official demanded CA, that is Constituent Assembly, to frame the Indian Constitution. 1938. Jawaharlal Nehru, on behalf of the INC, that is Indian National Congress, declared that the Constitution of Free India must be framed without outside interference by a Constituent Assembly elected on the basis of adult franchise. 1940. Demand accepted in principle in August offer. 1940. Demand accepted in principle in August offer. 1942. Cripps proposal for constitution rejected. 1946. Cabinet Mission Plan CMP accepted by all parties. Lord Patrick Lawrence, Sir Stanford Cripps, A.V. Alexander were its members. CMP rejected the idea of two constituent assemblies. Do you know? The Constitution drew its authority from the fact that members of the Constituent Assembly engaged in what one might call public reason, principle of deliberation. Introduction of universal suffrage was only one provision of the Indian Constitution. Introduction of universal suffrage was only one provision of the Constitution Introduction of the universal suffrage was only one provision of the Constitution which passed without virtually any debate. Composition of the Constituent Assembly constituted on November 1946 under Cabinet Mission Plan. Strength total 389 is equal to 299 British India plus 93 princely state plus 4 chief commissioners provinces. Composition. Representatives of all sections of the Indian society: Hindus, Muslims, Sikhs, Parsis, Anglo-Indians, Indian Christians, SCs, STs, including women of all these sections. Seats allotted in proportion to their respective population. 1 seat is equal to 1 MN. Seats allocation divided among the 3 principal communities: Muslims, Sikhs, and general, all except Muslims and Sikhs, in proportion to their population. Voting method. Proportional representation by means of single transferable vote in case of provincial representation. Members partly elected in British provinces and partly nominated by heads of princely state body. Members who were to be indirectly elected by the members of the provincial assemblies. Note: Mahatma Gandhi was not part of Constituent Assembly. The 93 seats allotted to the princely states were not filled as they decided to stay away from the Constituent Assembly. Representatives of the princely states who had stayed away from the Constitution Assembly gradually joined it. Members of the Muslim League from Indian Dominion also entered the assembly after acceptance of Mountbatten Plan of Partition, June 3, 1947. Working of the Constituent Assembly. First meeting. Held on December 9, 1946, Muslim League boycotted. Attended by 211 members only. French practice. Dr. Sachidananda Sinha, oldest member, was elected as temporary president of the assembly following French practice. President. Later, Dr. Rajendra Prasad was elected president. Later, Dr. Rajendra Prasad was elected as President of Constituent Assembly. Vice President 2. H.C. Mukherjee and V.T. Krishnamachari. Vice Presidents 2. H.C. Mukherjee and V.T. Krishnamachari. Objectives resolution. Jawaharlal Nehru moved this historic resolution on December 13, 1946 in the Assembly. It contained the fundamentals and philosophy of constitutional structure. This resolution was adopted on January 22, 1947 by the Assembly. This resolution was adopted on January 22, 1947 by the Assembly. Present preamble of the Constitution is modified version of the objective resolution. Final session. Total sessions 11. January 24, 1950. It, however, continued as the Provincial Parliament of India from January 26, 1950 till the formation of the new Parliament after the first general elections in 1951-1952. Final session. Total sessions 11. January 24, 1950. It, however, continued as the Provincial Parliament of India from January 26, 1950 till the formation of the new Parliament after the first general elections in 1951 and 1952. The Constituent Assembly had 11 sessions over 2 years. The Constituent Assembly had 11 sessions over 2 years, 11 months and 18 days. The Constituent Assembly had 11 sessions over 2 years, 11 months and 18 days. Changes by the Independent Act 1947. Members of princely states and Muslim League from Indian Dominion gradually began to join after acceptance of Mountbatten Plan of June 3, 1947. This plan provided for partition. Indian Independence Act 1947 made 3 changes in Constituent Assembly. The Assembly was made a fully sovereign body, free to abrogate or alter any law. 2 separate functions were assigned to the Assembly, performed on separate days. Legislative body chaired by G.V. Malavankar and constituent body chaired by Dr. Rajendra Prasad. Assembly became the first parliament of Free India Dominion. Assembly became the first parliament of Free India Dominion legislature. These two functions continued till November 26, 1949. After withdrawal of Muslim League members, total strength came down to 299, as against 389 under the Cabinet Mission Plan. Enactment and enforcement of the Constitution. Enactment. It was adopted on November 26, 1949. Out of a total 299 members of the Assembly, only 284 were actually present on that day and signed the Constitution. At that time, it contained preamble, 395 articles, and 8 schedules. Preamble was enacted after the entire Constitution was already enacted to align with the philosophy of the Constitution. Enforcement. Some provisions of the Indian Constitution came into force on November 26, 1949 itself, with citizenship, elections, provisional parliament, temporary and transitional provisions, and short title contained in Article 5, 6, 7, 8, 9, 60, 324, 366, 367, 379, 380, 388, 391, 392, and 393. Major part came into force on January 26, 1950. Commencement Day, celebrated as Republic Day. January 26, 1930. Purna Swaraj Day was celebrated following Lahore session, December 1929 of the Indian National Congress. Indian Independence Act 1947 and Government Act 1935 with all its enactments were repealed. However, the abolition of Privy Council Jurisdiction Act 1949 continued. Major committees of Constituent Assembly. In the Constituent Assembly, 8 were major committees and few others were minor committees. The names of these committees and their chairmen are as given below. First, Union Powers of Committee, Jawaharlal Nehru. Union Constitution Committee, Jawaharlal Nehru. Provincial Constitution Committee, Sardar Patel. Drafting Committee, B.R. Ambedkar. Advisory Committee on Fundamental Rights, Minorities and Tribal and Excluded Areas, Sardar Patel. Rules of Procedure Committee, Dr. Rajendra Prasad. States Committee for Negotiating with States, Jawaharlal Nehru. Steering Committee, Rajendra Prasad. Dr. Rajendra Prasad. Minor Committees of Constituent Assembly, Finance and Staff Committee, Dr. Rajendra Prasad. Credentials Committee, Alladi Krishnaswamy Iyer. House Committee, B. Pattabhi Sitaramaiah. Order of Business Committee, Dr. K.M. Munshi. Ad Hoc Committee on the National Flag, Dr. Rajendra Prasad. Committee on the Functions of the Constituent Assembly, G.V. Malvankar. Ad Hoc Committee on the Supreme Court, S. Vardhachari, not an Assembly member. Committee on Chief Commissioners Provinces, B. Pattabhi Sitaramaiah. Expert Committee on the Financial Provisions of the Union Constitution, Nalani Rajan Sarkar, not an Assembly member. Linguistic Provisions Commission, S.K. Dar, not an Assembly member. Special Committee to examine the draft Constitution, Jawaharlal Nehru. Press Gallery Committee, Usha Nath Sen. Ad Hoc Committees on Citizenship, S. Vardhachari, not an Assembly member. Drafting Committee. Among all the committees, the most important and the pivotal committee was the 7-member Drafting Committee set up on August 29, 1947. Drafting Committee. Among all the committees, the most important and pivotal committee was the 7-member Drafting Committee set up on August 29, 1947. It was this committee that was entrusted with the task of preparing a draft for the new constitution. Members of this committee were: first, B.R. Ambedkar, Chairman; second, Gopal Swamy Iyer,
Gopalswamy Ayyanar, Gopalswamy Ayyanagar. Third, Alladi Krishnaswamy Iyer. Fourth, Dr. K. Munshi. Fifth, Sayyid Muhammad Sadullah. Sixth, N. Madhavana Rao. N. Madhava Rao. He replaced B.L. Mitter, who resigned due to ill health. Seventh, T.T. Krishnamachari. He replaced D.P. Kaithan, who died in 1948. Drafting Committee, after taking into consideration the proposals of various committees, prepared the first draft of the Constitution of India, which was published in February 1948. The people of India were given 8 months to discuss the draft and propose amendments. The drafting committee prepared a second draft, which was published in October 1948. The drafting committee took less than 6 months to prepare this draft. The drafting committee prepared a second draft, which was published in October 1948. The drafting committee took less than 6 months to prepare its draft. In all, the drafting committee sat only for 141 days. Functions performed by the Constituent Assembly: making of the Constitution and enacting of ordinary laws. Ratified India's membership of the Commonwealth in May 1949. Adopted the national flag on July 22, 1947. Adopted the national anthem on January 24, 1950. Adopted the national song on January 24, 1950. Adopted the national flag on July 22, 1947. Adopted the national anthem on January 24. Adopted the national anthem on January 24, 1950. Adopted the national song on January 24, 1950. It elected Dr. Rajendra Prasad as the first president of India on January 24, 1950. Do you know the Constitution as adopted on November 26, 1949 contained preamble, 395 articles and 8 schedules. January 26th as date of commencement in 1930. Purna Swaraj Day was celebrated at the Lahore session, December 1929 of the Indian National Congress. The preamble was enacted after the entire constitution was already enacted to align with the philosophy of the constitution. Components of the interpretation of the constitution: Constitutional Assembly debates, doctrine of the liberal interpretation, tools evolved by the judiciary, apex court. Doctrine of progressive interpretation in alignment with contemporary realities. Doctrine of progressive interpretation in alignment with the contemporary realities. Doctrine of prospective interpretation. Article 367, General Clauses Act 1897. Article 367, General Clauses Act 1897. Hindi text of the Indian Constitution. In its original form, the Constitution of India did not make any provisions with respect to the authoritative text of the Indian Constitution. In its original form, the Constitution of India did not make any provisions with respect to an authoritative text of the Constitution in the Hindi language. In its original form, the Constitution of India did not make any provisions with respect to an authoritative text of the Constitution in Hindi language. However, later provisions in this regard was made by the 58th Constitutional Amendment Act of 1987. This amendment inserted a new article, 394A, in the part 12, last part of the Constitution. This article contains the following provisions: the president shall cause to be published under his authority the translation of the Constitution in Hindi language, the modification which are necessary to bring it in conformity the translation of the Constitution in Hindi language, the modification which are necessary to bring it in conformity with the language, style, terminology adopted in authoritative texts of the central acts in Hindi can be made in it. All the amendments of the Constitution made before such publication should be incorporated in it. Translation in Hindi of every amendment of the Constitution made in English. The translation of Hindi of every amendment of the Constitution made in English. The translation of the Constitution and its every amendment published shall be construed. The translation of the Constitution and its every amendment published shall be construed to have the same meaning as the original text in English. Shall be construed to have the same meaning as the original text in English. If any difficulty arises in this matter, the President shall cause the Hindi text to be revised suitably. If any difficulty arises in this matter, the President shall cause the Hindi text to be revised suitably. The translation of the Constitution and its every amendment published shall be deemed to be for all purposes in its authoritative text in Hindi. The translation of the Constitution and its every amendment published shall be deemed to be for all purposes its authoritative text in Hindi. The translation of the Constitution and its every amendment published shall be deemed to be for all purposes its authoritative text shall be the translation of the Constitution and its every amendment published shall be deemed to be for all purposes in its authoritative text in Hindi. Criticism of Constituent Assembly and the Constitution. Non-representative composition, not directly elected by the people of India on the basis of universal adult franchise, dominated by Congress. 82% seats of Assembly were held by Indian National Congress. Constitution is an un-Indian and slavish imitation of Western constitutions. Time-consuming exercise. Final drafting took almost a 3-year span. Elephantine-sized and complicated language. Lawyer's paradise. Elephantine-sized and complicated language. Lawyer's paradise. Un-Gandhian nature of Constitution, although not sidelined completely. Un-Gandhian nature of Constitution. Communities' opposition to parliamentary democracy. Communists opposition to parliamentary democracy. Carbon copy of 1935 Act or amendment version of 1935 Act. Limitations of the Constitution. The Indian Constitution has a centralized idea of national unity. It appears to have glossed over some important issues of gender justice, particularly within the family. Certain basic socio-economic rights were regulated to the section on directive principles rather than made an integral feature of our certain basic social limitations of the Constitution. Indian Constitution has a centralized idea of national unity. It appears to have glossed over some important issues of gender justice, particularly within the family. It appears to have glossed over some important issues of gender justice, particularly within the family. Certain basic socio-economic rights were regulated in the section on directive principles rather than made an integral feature of our fundamental rights. Experts Committee of the Congress. On July 8, 1946, the Congress Party, Indian National Congress, appointed an experts committee for the purpose of preparing material for the Constituent Assembly. Members of the committee were Jawaharlal Nehru, Chairman, M. Asaf Ali, K. Munshi, Gopalswamy Iyengar, K.T. Shah, D.R. Gadgil, Humayun Kabir, K. Santhanam. Important facts about Indian Constitution and Constituent Assembly. Elephant adopted as Constituent Assembly symbol. Sir B.N. Rao was constitutional advisor. To Constituent Assembly. H.V.R. Iyengar was secretary to the Constituent Assembly. S.N. Mukherjee was chief draftsman of Constitution in the Constituent Assembly. Prem Bihari Raizada was the calligrapher of the Constitution. Calligraphy classes. Nandlal Bose and B.R. Sinha decorated and beautified the Constitution. Hindi version calligraphy done by Vasant Krishnan Vaidya and illuminated by Nandlal Bose. Total sessions 11. Total time 2 years, 11 months and 18 days. Total expenditure incurred 64 lakh. Time taken by the framers of Constitution in other countries. US less than 4 months. South Africa 1 year. Australia 9 years. Canada 2 years and 6 months. Third chapter. Salient features of the Indian Constitution. Introduction. The 42nd Constitutional Amendment 1976 is also called as mini constitution. Keshavananda Bharati case 1973. Supreme Court ruled constituent power of Parliament doesn't allow it to change the basic structure of the Constitution. Minerva Mills case 1980. Supreme Court held that Indian Constitution is founded on the bedrock of the balance between the fundamental rights and the directives principle of state policy's basic structure. Significant features of the Constitution. Lengthiest written Constitution. Originally in 1949, the Constitution contained a preamble, 395 articles divided into 22 parts and 8 schedules. Factors underlying elephantine size, vastness of the country and its diversity, historical factors, single constitution for both center and states, dominance of legal luminaries in the Constituent Assembly. Presently, it consists of a preamble, about 470 articles and 12 schedules. Drawn from various sources, the Constitution of India has borrowed most of its provisions from the constitutions of various other countries as well as from the Government of India Act of 1935, federal system with unitary bias. The term federation has nowhere been used in the Constitution. Article 1 describes India as a union of states. Federal feature: 2 governments, division of powers, written constitution, bicameralism, supremacy of the Constitution, etc. Unitary, non-federal features: strong center, single constitution, single citizenship, integrated judiciary, all India services, emergency provisions, etc. Rigidity and flexibility. The Indian Constitution is neither rigid like USA nor flexible like Britain, but a blend of both. Parliamentary form of government. The Indian Constitution has preferred British parliamentary system, Westminster model of government, over the American presidential system of government, where the executive remained responsible to the parliament. The Constitution establishes the parliamentary system at the center and also in the states. Features: the presence of nominal and real executives, rule of majority party, leadership of the Prime Minister or the Chief Minister, membership of the ministries in the legislature, dissolution of the lower house, Lok Sabha, synthesis of parliamentary sovereignty and judicial supremacy. Sovereignty of Parliament associated with the British Parliament, judicial supremacy associated with the American system. Integrated and independent judiciary. The Supreme Court stands at the top of the integrated judicial system in the country, followed by high courts in the states and subordinate courts and other lower courts. Supreme Court, highest court of appeal. Guarantor of fundamental rights of the citizens, guardian of the Constitution. India, single system of courts, enforces both the central laws as well as the state laws. Provides for procedure established by the law. Article 21. USA, federal laws are enforced by the federal judiciary and the state laws are enforced by the state judiciary. Provides for the dual purpose of law. Provides for due process of law. Fundamental rights, meant for promoting the ideas of political democracy. Part 3 of the Constitution guarantees 6 fundamental rights to all citizens. Right to equality, Article 14 to 18. Right to freedom, Article 19 to 22. Right against exploitation, Article 23-24. Right to freedom of religion, Article 25 to 28. Cultural and educational rights, Article 29 to 30. Right to constitutional remedies, Article 32. Note: again, fundamental rights, meant for promoting the ideas of political democracy. Part 3 of the Constitution guarantees 6 fundamental rights to all citizens. Right to equality, Article 14 to 18. Right to freedom, Article 19 to 22. Right against exploitation, Article 23 to 24. Right against freedom of religion, Article 25 to 28. Cultural and educational rights, Article 29 to 30. Right to constitutional remedies, Article 32. Note: under Article 32, if a fundamental right of any Indian citizen is violated, then the aggrieved person can directly go to the Supreme Court, which can issue writs of habeas corpus, mandamus, prohibition, certiorari quo warranto, for the restoration of his or her rights. Exception: they can also be suspended during the operation of national emergency, except the rights guaranteed by the Article 20 and 21. Exception: they can also be suspended during the operation of national emergency, except the rights guaranteed by the Articles 20 and 21. Directive Principles of State Policy, Part 4 of the Constitution. To promote the ideas of Directive Principles of State Policy, Part 4 of the Constitution, to promote the ideals of social and economical democracy, non-justiciable in nature, that is, they are non-enforceable by the courts for their violation. Classified into 3: socialistic, Gandhian, and liberal intellectual. Aim: to establish a welfare state in India. Significance: fundamental in the governance of the country, and it shall be the duty of the state to apply these principles in making laws. Fundamental duties, added to the Constitution by 42nd Amendment Act, only after the recommendations of Swaraj Singh Committee. Part 4A of the Constitution, only one Article 51A specifies the 11 fundamental duties. 86th Constitutional Amendment 2002 added one more duty: non-justiciable in nature. Secular state. The term secular was added to the preamble by the 42nd Constitutional Amendment Act 1976. It does not uphold any particular religion as the official religion of the Indian state. Western concept of secularism. Complete separation between the religion, the church, and the state, the politics. The Indian concept of secularism embodies the positive concept of secularism, that is, giving equal respect to all religions and or protecting all religions equally. Articles promoting secularism. Preamble. Article 14, 15, 16, 25, 30, 25 to 30 and 44. Universal adult franchise. The voting age was reduced to 18 years from 21 years in 1989 by 61st Constitutional Amendment Act 1988. Universal adult franchise. Basis of the elections to the Lok Sabha and the state legislative assemblies. Single citizenship. India enjoy the same political and civil rights of citizenship all over the country. USA. Each person is not only a citizen of the USA but also a citizen of the particular states to which he belongs. Independent bodies. Bulwarks of the democratic system. Election Commission. Comptroller and Auditor General. Union Public Service Commission, State Public Service Commission. Emergency provisions. Rationality behind provisions to safeguard the sovereignty, unity, integrity, security of the country, the democratic political system, and the constitution. Rationality behind provisions to safeguard the sovereignty, unity, integrity, and security of the country, the democratic political system, and the constitution. National emergency. Article 352. State emergency or president's rule. Article 356, Article 360, Article 365. Financial emergency. Article 360. Unique feature. During an emergency, federal structure converts into unitary. Unique feature. During an emergency, federal structure converts into unitary one without a formal amendment of the Constitution. Three-tier government. 73rd Constitutional Amendment 1992. Constitutional recognition to panchayats. Part 9th, Schedule 11. 74th Constitutional Amendment Act 1992. Constitutional recognition to municipalities. Part 9th A. Schedule 12th. Schedule 12th. Article 40. Organization of village panchayats. Gandhian principle. Cooperative societies. 97th Constitutional Amendment 2011. Constitutional status and protection to cooperative societies. Right to form cooperative societies as a fundamental right. Article 19. Added a new directive principle of state policies on promotion. Added a new directive principle of state policies on promotion of cooperative societies. Article 43B. Article 43B. Added a new part 9B entitled as Cooperative Societies. Article 243 ZH to Article 243 ZT. Previous year questions, PYQs of prelims. Consider the following statements. First, the Constitution of India defines its structure in terms of federalism, secularism, fundamental rights, and democracy. Second, the Constitution of India provides judicial review to safeguard the citizens' liberties and to preserve the ideals on which the Constitution is based. Which of the statements given above are correct? The answer is only 2 is correct. So the first statement is incorrect, which goes like, the Constitution of India defines its structure in terms of federalism, secularism, fundamental rights, and democracy. This is incorrect statement. And the second statement, which says The Constitution of India provides for judicial review to safeguard the citizens' liberties and to preserve the ideals on which the Constitution is based. This statement is correct. The Constitution of India provides for judicial review to safeguard the citizens' liberties and to preserve the ideals on which the Constitution is based is the correct statement. Sources of the Constitution. One likes to ask whether there can be anything new in a constitution framed at this hour in the history of the world. One likes to ask whether there can be anything new in a constitution framed at this hour in the history of the world. The only new thing, if there can be any, in a constitution framed so late in a day. The only new thing, if there can be any, in a constitution framed so late in the day are the variations made to remove the failures and accommodate it to the needs of the country. One likes to ask whether there can be anything new in a constitution framed at this hour. Whether there can be anything new in a constitution framed at this hour in the history of the world. The only new thing, if there can be any, in a constitution framed so late in a day are the variations made to remove the failures and accommodate it to the needs of the country. B.R. Ambedkar. Government of India Act 1935. Sources and features borrowed. Okay. So the sources are from which the features of the Constitution are borrowed. First, Government of India Act 1935. So our Constitution borrowed from the Government of India 1935 is the federal scheme, Governor's Office, Judiciary, Public Service Commission, emergency provisions, and administrative details. Second, British Constitution. So our Indian Constitution borrowed from British Constitution the following: parliamentary government, rule of law, single citizenship, cabinet system, parliamentary privileges, bicameralism, prerogative writs, prerogative writs. Third, US Constitution. So this means our Indian Constitution has borrowed from the US Constitution the following: fundamental rights, independent judiciary, impeachment of president, judicial review, removal of Supreme Court and High Court judges, and the post of vice president. Irish Constitution, DPSP, method of election of president and nomination of members to Rajya Sabha. Canadian Constitution, federation with a strong center, vesting residuary powers to center, appointment of state governors by the center, and advisory jurisdiction of Supreme Court. Australian Constitution, concurrent list, joint sitting of both houses of parliament. Weimar Constitution of Germany, suspension of fundamental rights during emergency. USSR Constitution, fundamental duties and the ideal of justice, social, economic and political in the preamble. French Constitution, republic and the ideals of liberty, equality and fraternity in the preamble. South African Constitution, procedure for amendment of the Constitution and election of members of Rajya Sabha. Japanese Constitution, procedure established by law. Part of the Constitution and their sources. Part of the Constitution and derived from. Structure part of the Constitution. Structural part of the Constitution. Government of India Act 1935. Philosophical part of the Constitution. Fundamental rights and directive principle of state policies. American and Irish American and Irish Constitution. American and Irish Constitution respectively. American and Irish Constitution respectively. American and Irish Constitution respectively. Political part of the Constitution. British Constitution. Important schedules of the Constitution. Schedule first. Schedule and subject names. First, the names of the states and their territorial jurisdiction, plus names of the union territories and their extent. Second, provisions related to the provisions related to emoluments, allowances, privileges of President of India, governors of state, Speaker and the Deputy Speaker of Lok Sabha and Legislative Assembly in states, judges of Supreme Court and High Courts, CAG of India, Chairman and Deputy Chairman of Rajya Sabha and Legislative Council in states. Note: PM, MPs, CM and MLAs are not covered. Third, oaths and affirmations for Union Ministers, candidates for election to Parliament, MPs, judges of Supreme Court and High Court, and the CAG, the candidates for election to the state legislature, members of the state legislature, etc. Fourth, allocation of seats in the Rajya Sabha to the seats and the UTs, that is, Union Territories. Fifth, provisions related to the administration and control of scheduled areas and scheduled tribes. Sixth, provisions related to the administration of tribal areas in the states of Assam, Meghalaya, Tripura, and Mizoram. Seventh, division of powers between the union and the state. Division of powers between the union and states in terms of union list, state list, and concurrent list. Eighth, languages recognized by the Constitution. Originally it was 14 and currently it is 22. Ninth, acts and regulations of the state legislatures dealing with the land reforms and abolition of the zamindari system. Ninth, acts and regulations of the state legislature dealing with the land reforms and abolition of the zamindari system. This schedule was added by the First Amendment 1951 by then PM Jawaharlal Nehru. 10th, anti-defection law was added by the 52nd Constitutional Amendment Act of 1985. 11th, related to the Panchayat, schedule was added by the 73rd Constitutional Amendment Act 1992. 12th, कसं बोलायचं? 12th, related to municipalities, schedule was added by the 74th Constitutional Amendment Act 1992. Previous year questions, prelims. First, under which schedule of the Constitution of India can transfer of tribal land to private parties for mining? Under which schedule of the Constitution of India can the transfer of tribal land to private parties for mining be declared null and void? 3rd schedule, 9th schedule, 5th schedule, 12th schedule. So the answer to this is B, 5th schedule. So under the 5th schedule of the Constitution of India, the Constitution of India can transfer and under which schedule the Constitution of India can transfer under which schedule of the Constitution of India can the transfer of the tribal under which schedule of the Constitution of India can the transfer of the tribal land to private parties for mining be declared null and void? Fifth schedule. Provisions related to the administration and control of scheduled areas and scheduled tribes. Fifth schedule. Under the fifth schedule of the Constitution of India, the transfer of tribal. Under fifth schedule of the Constitution of India, the transfer of land. Previous year questions prelims first. Under which schedule of the Indian Constitution? Previous year questions prelims first. Under which schedule of the Constitution of India can the transfer of tribal land to private parties for mining be declared null and void? The answer is fifth schedule. This was asked in 2019. So the answer would be, under the fifth schedule of the Constitution of India, the transfer of tribal land to private parties for mining can be declared. So the answer goes like under the fifth schedule of the Indian Constitution. So the answer to this question goes like, under the fifth schedule of the Constitution of India, the transfer of tribal land to the private parties for mining can be declared null and void. The ninth schedule was introduced in the Constitution of India during the prime membership of Jawaharlal Nehru. Third question. The provisions in the fifth schedule and the sixth schedule in the Constitution of India are made in order to A. Protect the interests of the scheduled tribes. B. Determine the boundaries between the states. C. Determine the powers and authority and responsibilities of Panchayat. D. Protect the interests of all the border states. Correct answer is A. So the answer goes like, the provisions of the fifth schedule and the sixth schedule in the Constitution of India are made in order to protect the interest of scheduled tribes. Fourth question. Which one of the following schedules of the Constitution of India contains provisions regarding the anti-defection? Second schedule, fifth schedule, eighth schedule, 10th schedule. This question was asked in 2014. Answer to this is 10th schedule. So the answer goes like, under the 10th schedule of the Constitution of India contains provisions regarding anti-defection. Concept of separation of power. In India, a separation of function rather than power is followed. Unlike in the US, in India, the concept of separation of power is not adhered to strictly. Unlike in the US, in India, the concept of separation of power is not adhered to strictly. India follows a mixed separation of power model, unlike in the USA. System of checks and balances have been put in place in India. Article 50, obligation over the state to separate the judiciary from the executive. Article 123, ordinance making power of the president in certain conditions. Article 121 and 211 and 211. Legislatures cannot discuss the conduct of a judge of a Supreme Court or High Court. Legislatures cannot discuss the conduct of a judge of the Supreme Court or High Court. They can do so only in the case of the impeachment. Significance of the separation of power doctrine. Keeps autocracy away, corruption, nepotism, abuse of power. Safeguards individual liberty. Helps create an efficient administration. Judiciary's independence is maintained. Promotes division of labor, efficiency, specialization. Prevents the legislature from enacting arbitrary or unconstitutional laws. Exceptions to separation of power. Setting up independent regulator for sector of economy. Executive conferred with the judicial powers. SDM, DM, Tehsildar. Parliamentary form of government. Executives are members of the legislature. Schemes such as MP, LAD, etc. By 42nd Amendment 1976, 5 subjects moved from state list to concurrent list. First, forest. Second, weights and measures. Third, protection of wildlife. Fourth, third, protection of wildlife. Third, protection of wildlife. Protection of wildlife. Protection of wildlife. Fourth, wildlife. Fourth, administration of justice and organization of subordinate courts. 5. Education, excluding primary. Constitutional morality. The Supreme Court had relied on constitutional morality to allow entry of women of all ages into the Constitutional morality. The Supreme Court had relied on constitutional morality to allow entry of women of all ages into the Sabarimala temple. The Supreme Court had relied on constitutional morality to allow entry of Constitutional morality. The Supreme Court had relied on constitutional morality to allow entry of women of all ages into the Sabarimala temple. Under a 4-1 majority verdict. Introduction. Constitutional morality means adherence to or being faithful to the bottom of the line. Constitutional morality means adherence to or being faithful to bottom line principles of the constitutional values. It includes commitment to an inclusive and democratic political process in which both individual and collective interests are satisfied. Constitutional morality is the soul of the Constitution, which is to be found in the preamble of the Constitution. The major elements of the constitutional morality in the context of Indian Constitution are rule of law, right to equality, rule of law, social justice, unity and integrity of nation, social justice, secularism, individual liberty and freedom of expression, etc. Origin. The doctrine of constitutional morality traces its origin back to the work of English historian George Grote. The doctrine of constitutional morality traces its origin back to the work of English historian George Grote. Signifies application. According to B.R. Ambedkar, it would remain effective coordination between conflicting interests of different people and the administrative cooperation to resolve them amicably without any confrontation amongst the various groups working for the realization of their according to Dr. Ambedkar, it would mean effective coordination between conflicting interests of different people and the administrative cooperation to resolve them amicably without any confrontation amongst the various groups working for the realization of their ends at any cost. Associated judgments. Sabarimala case 2018. Supreme Court held the religious freedom, gender equality and the right of women to worship guaranteed in the Constitution of India. Keshwananda Bharti case 1973. Supreme Court restricted the power of the Parliament to violate the basic structure of the Constitution. Supreme Court restricted the power of the Parliament to violate the basic structure of the Constitution. Nas Foundation case. Supreme Court opined that Nas Foundation case. Supreme Court opined that only constitutional morality, not public morality, should prevail. Supreme Court opined that only constitutional morality should prevail, not the public morality. Navtej Singh Johar versus Union of India. Supreme Court struck down the archaic provisions of Section 377 and upheld the constitutional morality. Lieutenant Governor of Delhi case. Supreme Court held that constitutional morality as controlling notion that highlights the need to sustain people's trust in the institution of democracy. In the case of Lieutenant Governor of Delhi. Constitutional provisions. Preamble, Article 12 to 35, Article 36 to 51, Article 51A. Previous year question. Mains. Constitutional morality is rooted in the Constitution itself and is founded on its essential facts facets. Explain the doctrine of constitutional morality with the help of the relevant judicial decisions. Preamble, Chapter 4, Preamble of Constitution. Preamble as the identity card of the Constitution. N.A. Palkhiwala. Basics of Preamble. Preamble of Indian Constitution is a preface or introduction that sets out the guiding purpose, principle and philosophy of the Constitution. We, the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and to secure to all its citizens justice, social, economical, and political, liberty of thought, expression, belief, faith, and worship, equality of status and of opportunity, and to promote among them all fraternity, assuring the dignity of the individual and the unity and integrity of the nation. In our Constituent Assembly, this 26th day of November 1949, do hereby adopt, enact, and give to ourselves this Constitution. Preamble contains the grand and noble vision of the Constituent Assembly and reflects the dreams and aspirations of the founding Preamble contains the grand and noble vision of the Constituent Assembly and reflects the dreams and aspirations of the founding fathers of the Constitution. Objective resolution drafted and moved by Pandit Nehru, December 13, 1946, serves as blueprint for preamble to the Indian Constitution. The American Constitution was the first to begin with a preamble. Preamble explains the purposes and objectives of the Constitution and provides a guideline to the Constitution, embodies the basic philosophy and fundamental values, political, moral, and religious, on which the Constitution is based. Preamble is neither a source of power to the legislature nor a prohibition on powers of legislature. Preamble is non-justiciable, non-enforceable in the courts of law. M. Hidayatullah. Preamble resembles the Declaration of Independence of the United States of America. We, the people of India, emphasis that the Constitution is made by and for all the people. We, the people of India, emphasizes that the Constitution is made by and for the Indian people. It emphasizes the concept of popular sovereignty and entails all the power emanating and entails all the power emanating from the people, and the political system will be accountable and responsible to the people. We, the people of India, emphasizes that Constitution is made by and for the Indian people. We, the people of India, emphasizes that the Constitution is made by and for the Indian people. It emphasizes the concept of popular sovereignty and entails all the power emanating from the people, and the political system will be accountable for responsible. We, the people of India, emphasizes that we, the people of India, emphasizes that the Constitution is made by and for the Indian people. It emphasizes the concept of popular sovereignty and entails all the power emanating from the people, and the political system will be accountable and responsible to the people. Preamble gives an idea about the following. Source of authority of the Constitution derives its authority from the people of India. Nature of Indian state: sovereign, socialist, secular, democratic republic. Objectives of the Constitution: justice, Russian Revolution; liberty, equality, fraternity, all three from French Revolution. Date of adoption of the Constitution: 26th November 1949. Do you know, preamble was enacted by the Constitution Do you know, preamble was enacted by the Constituent Assembly after the rest of the Constitution was already enacted to ensure its conformity with the Constitution. To ensure its conformity with the Constitution. Do you know, preamble was enacted by the Constituent Assembly after the rest of the Constitution was already enacted to ensure its conformity with the Constitution. Keywords in preamble: sovereign. India is externally sovereign, free from the control of any foreign power. India is internally sovereign, free from government which is directly elected by the people and makes laws that govern the people. No external power can dictate the government of India. As a sovereign country, India can acquire a foreign territory or cede a part in favor of any other country. Or cede a part in favor of any other country. As a sovereign country, India can acquire a foreign territory or cede a part in favor of any other country. Socialist. Added by the 42nd Amendment 1976. Socialist. Added by 42nd Amendment 1976. Socialist contents are implicit in directive principles of state policies, Article 36 to 51. But 42nd Amendment mentioned it explicitly. Socialism as an economic philosophy. India adopted mixed economy. Indian socialism, Marxism plus Gandhism, heavily leaning towards Gandhism. Democratic socialism adopted mixed economic model. Public and private sector coexist side by side. Socialism as a social philosophy stresses more on societal equality, societal equity and equality. Democratic socialism aims to end poverty, ignorance, disease and inequality of opportunity as observed by the Supreme Court. Secular. Added by 42nd Amendment 1976, Supreme Court 1974. Secular state was implicitly mentioned in Article 25 to 28. 28. Positive secularism in India. State will have no religion of its own. State will have no religion of its own. And all persons will be equally entitled to the freedom of conscience and the right freely to proceed. Secular added by 42nd Amendment 1976, Supreme Court 1974. Secular state was implicitly mentioned in Article 25 to 28. Positive secularism in India. State will have no religion of its own, and all persons will be equally entitled to the freedom of the conscience and all the people. State will have no religion of its own, and all the persons will be equally entitled to the freedom of the conscience and the right freely to profess, practice, and propagate the religion of their choice. S.R. Bomai and others. S.R. Bomai and others versus Union of India. Constitutional basis. Preamble. Article 14, 15, 16, 25 to 28, 29 to 30, 44, 325, etc. 325, etc. Secularism is a part of basic structure of the Constitution. Democratic. Constitution has established a form of government which gets its authority from the will of the people. Doctrine of popular sovereignty. The rulers are elected by the people and are accountable to them. The phrase democratic the rulers are elected by the people and are accountable to them. Phrase democratic entails political plus social plus economic democracy. Political democracy cannot last unless it lies at the base of its social democracy. Social democracy is equal to liberty plus equality plus fraternity. Political democracy cannot last unless it lies at the base of. Phrase democratic entails political plus social plus economic democracy. Political democracy cannot last. Political democracy cannot last unless it lies at the house. Political democracy cannot last unless it lies at the base of its social. Political democracy cannot last until it lies at the base of its social democracy. Social democracy is equal to liberty plus equality plus fraternity. Representative parliamentary democracy of India. Universal adult franchise, periodic elections, rule of law, independent judiciary, absence of discrimination on certain grounds. Instruments of direct democracy. Instruments of direct democracy. Referendum. Procedure whereby a proposed legislation is referred to the electorate for settlement by their direct votes. Initiative. Method by means of which the people can process a bill. Methods by means of which the people can propose a bill to the legislature for the enactment. Recall. Method by means of which the voters can remove a representative or an officer before the expiry of his term. Plebiscite. Plebiscite method of obtaining the opinion of people on any issue of public importance. It is generally used to solve the territorial disputes. Republic. Democratic polity is classified into two categories: monarchy, Britain, and republic, USA, India. Republic means vesting political sovereignty. Republic means vesting political sovereignty in people, absence of any privileged class, and all public offices open to all without any discrimination. Democratic republic entails elected head of the state directly or indirectly. Democratic republics entails elected head of state directly or indirectly for a fixed tenure. President of India indirectly. President of India indirectly elected for a period of 5 years. President of India indirectly President of India indirectly elected for a period of 5 years. Indian Republic, head of the state, president is indirectly elected. Article 54 and 55 related to the election of the president. Liberty, French Revolution 1789. Ideals of liberty, equality, fraternity, absence of restraints on the activities of individuals, providing opportunities for the development of the individual personalities. Preamble secures liberty of thought, expression, belief, faith, and worship. Liberty does not mean license to do what one likes, need to be enjoyed within limitations mentioned in the Constitution. Liberty ensures in preamble and fundamental rights is not absolute but qualified. Positive liberty recognizes that one can be free only in society and not outside it. Therefore, it is the possibility of acting or the fact of acting in such a way as to take control of one's life and realize one's fundamental purposes. Realize one's fundamental purposes. Negative liberty. It is concerned with the inviolable area of non-interference and not with the conditions in society, that is, absence of obstacles, barriers, or constraints. Equality. Absence of special privileges to any section of society, adequate opportunities for all without discrimination. Preamble secures equality of status and opportunity. Civil equality. Article 14, equality before law. Article 15, prohibition of discrimination on the grounds of religion, race, caste, sex, place of birth. Article 16, equality of opportunity in public employment. Article 17, abolition of untouchability. Article 18, abolition of titles. Political equality. Article 325. No one is ineligible for inclusion in the electorate. No one is ineligible for the inclusion in the electoral rolls on the grounds of religion, race, caste, or sex. Article 326. Lok Sabha and State Assembly elections based on adult franchise. Economic equality. Article 39. Equal right to adequate means of livelihood and equal pay for equal work. To men and women. Fraternity. Sense of brotherhood. Single citizenship promotes fraternity. Article 51A. Fundamental duty of every citizen to promote harmony and spirit of common brotherhood, transcending religious, linguistic, regional, or sectional diversities. Fraternity. Dignity of individual, personality of every individual is sacred, and unity and integrity of India. Word integrity is added through 42nd Constitutional Amendment Act. Dignity of individuals is ensured in fundamental rights, directive principles of state policies. Fundamental duties. Unity and integrity of nation embraces both psychological and territorial dimensions of nation and of national. Unity and integrity of nation embraces both psychological and territorial dimensions of national integration. Union of Trinity is equal to liberty plus equality plus fraternity. All above three form a union of Trinity. If any of these If any of this is divorced from others, it will defeat the purpose of democracy. Without equality, liberty would produce the supremacy of the without equality, liberty would produce the supremacy of the few over many. Without equality, liberty would produce supremacy of few over many. Equality without liberty would kill individual initiative. Phrase dignity of the individual signifies that Constitution not only ensures material betterment, and the phrase dignity of individual phrase dignity of individual signifies that the Constitution not only ensures material betterment and maintenance phrase dignity of individual dignity of individual signifies that the Constitution not only ensures material betterment and maintain a democratic phrase dignity of the individual signifies that Constitution not only ensures material betterment and maintain a democratic setup, but it also recognizes phrase dignity of the individual signifies that the Constitution not only ensures material betterment and maintain a democratic setup, but it also recognizes phrase dignity of individual signifies that the Constitution not only ensures material betterment and maintain a democratic setup, but it also recognizes that the personality of every individual phrase dignity of the individual signifies that the Constitution not only ensures material betterment and maintain a democratic setup, but it also recognizes that the personality of every individual is sacred. K.M. Munshi. Significance of preamble. It is significance of preamble. It is an important guide and serves as a guiding light to interpret the true spirit of the Constitution, helps in determining the constitutional validity of the legislative or an executive action. Preamble is the horoscope of a sovereign democratic republic. K.M. Munshi embodies the basic philosophy and fundamental values, political, moral, and religious, on which the Constitution is based. It is the soul of our Constitution. Which lays down the pattern of our political society. It contains a solemn resolve which nothing but a revolution can alter. It is the soul of our Constitution. Which lays down the pattern of our political sovereign. It is the soul of our Constitution, which lays down the pattern of our political society. It contains a solemn resolve which nothing but a revolution can alter. M. Hidayatullah. Amendability of preamble. Whether the preamble can be amended or not was dealt in Keshananda Bharti case 1973. The Supreme Court reversed its verdict in Berubari Union case 1960 and held that preamble is an integral part of the Constitution and it can be amended under Article 368. However, such an amendment should not destroy the basic structure of the Constitution. So far, preamble has been amended only once by the 42nd Constitutional Amendment Act 1976. Added 3 new words: socialistic, secular, and integrity. Original preamble described the states as sovereign democratic republic. Now it reads sovereign socialist, secular, democratic republic. Judicial pronouncements. Preamble as a part of Constitution or not. Berubari Union case 1960. Although preamble assists at interpretation of the Constitution, and key to the minds of the makers of the Constitution, Supreme Court specifically opined that preamble is not part of the Constitution. Keshananda Bharti case. Supreme Court specifically opined that preamble is not a part of the Constitution. Keshananda Bharti case 1973. recognized the extreme importance of preamble and overruled its earlier decision, which was given in Berubari case 1965. And now the Supreme Court asserted that preamble is a part of the Constitution and it may be amended subject to the basic structure of doctrine. LIC of India case 1995 upheld. Keshananda Bharati case 1973 recognized the extreme importance of preamble and overruled its earlier decision. Berubari case 1965 and asserted preamble is a part of the Constitution and it may be amended subject to the basic structure of the doctrine. Basic structure of doctrine evolved. Basic structure of doctrine evolved. LIC of India case 1995 upheld the preamble and said that it is an integral part of the Constitution. Key phrases for mains: social democracy, liberty, equality, fraternity, unity of Trinity, distributive justice, social, economic, political, concept of popular sovereignty. Preamble as guiding light for judicial interpretation. Democratic socialism, unique blend of Gandhism and Marxism. Previous year questions, prelims. First, what was the exact constitutional status of India on 26th January 1950? The sovereign democratic republic, sovereign secular democratic republic, sovereign socialist secular democratic republic. This was asked in 2021. And the correct answer is B, a sovereign democratic republic. Second question, the preamble to the Constitution of India is a part of the Constitution but has no legal effect. Not part of the Constitution. A part of the Constitution but has no legal effect. Not a part of the Constitution and has no legal effect either. A part of the Constitution and has same legal effect as any other part. A part of the Constitution but has no legal effect independently of other parts. So the correct answer, and this was asked in 2020 exam. Correct answer is given as the D, that is a part of the Constitution but has no legal effect independently of other parts. So the answer would go like the preamble to the preamble to the Constitution of India is a part of the Constitution but has no. So the answer to this question would go like the preamble to the Constitution of India is a part of the Constitution but has no legal effect So the answer to this question would go like. So the answer to this question would go like the preamble to the Constitution of India is a part of the Constitution but has no legal effect independently of other parts. Again, the answer to this question would go like the preamble of the Constitution of India is a part of the Constitution but has no legal effect independent. Once again, this is for the last time. The preamble of the Constitution of India, the preamble of the Constitution of India is a part. The preamble of the Constitution of India is a part of the Constitution but has no legal effect independently of other parts. Third question, in the context of polity, which one of the following would you accept as the most appropriate definition of liberty? A. Protection against the tyranny. Protection against the tyranny of political rulers. B. Absence of restraint. C. Opportunity to do whatever one likes. D. Opportunity to develop oneself fully. Opportunity to develop oneself fully. This was asked in 2019. And the answer to this question is fourth option D, which is opportunity to develop oneself fully. Opportunity to develop oneself fully. So the answer would go like in the context of polity, which one of the following would you accept? Which one of the following would you accept as the most appropriate definition of liberty? Liberty's definition is most appropriate according to these examples, or among these examples is definition of the liberty: opportunity to develop oneself fully. Definition of liberty is opportunity to develop oneself fully. Question number 4, this was asked in 2018. Which one of the following reflects the most appropriate relationship between the law and liberty? A. If there are more laws, there is less liberty. If there are no laws, there is no liberty. If there is liberty, laws have to be made by the people. If laws are changed too often, liberty is in danger. Again, let's see the questions, the options again. If there are more laws, there is less liberty. If there are no laws, there are no liberty. There is no liberty. If there is liberty, laws have to be made by the people. If laws are changed too often, liberty is in danger. The correct option is B. That is, if there are no laws, there is no liberty. Question number 5. Which one of the following objectives is not embodied? Which one of the following objectives is not embodied in the preamble of the Constitution of India? Liberty of thought, liberty of expression, liberty of belief, or economic liberty? Economic liberty is the right answer. Once again, which one of the following objectives is not embodied in the preamble of the Constitution? Which one of the following objectives is not embodied in the preamble of the Constitution of India? Liberty of thought, economic liberty, liberty of expression, liberty of belief. The correct answer is economic liberty.